May it please the court, my name is James Johnson. I represent the appellant Kathy Leslie and Penthouse Hospitality Group in this appeal. And I'd like to reserve 3 minutes for rebuttal. Your
3
Honor.
minutes, yes,
3
sir.
minutes, Your Honor. Your Honor, the facts of this case are that in between 2016 and 2017, the appellants and the appellees entered into 3 different written promissory notes where the appellant, Kathy Leslie, agreed to pay back certain amounts of money to the appellee, Ms. Compton, over time. One of the notes did not involve Ms. Compton, but it involved, I believe, a relative of hers who eventually assigned his note to Ms. Compton. All of the notes had in them a provision that in the event of any defaults on any of those notes, that the parties would agree to arbitrate their issues. On December 18th, December 26th of 2018, Ms. Compton filed a cause of action against the appellant and her company, Penthouse Hospitality, because she alleges that Ms. Leslie had breached the contract by not repaying the money. After the causes of action were filed, Ms. Leslie, over time, filed 4 essentially motions to compel arbitration with the trial court. And the first motion that she filed to compel arbitration occurred on, let me check the date right here, March 15th of 2019, when she filed a motion to dismiss, and in that motion to dismiss, she alleged that the sole and exclusive remedy available to the plaintiff by virtue of the purported agreements and or related financial obligations upon which she is alleged entitlement to recover is through binding arbitration. That is what she filed and asked the court to do. The trial court denied that motion and essentially said, because the verified complaint alleges fraud, then this matter shall proceed to discovery on the allegation of fraud. However, if the allegation of fraud is proven, then the arbitration provision would be abrogated and arbitration would not be appropriate. If no fraud is proven, then this matter shall possibly proceed to arbitration. She then filed a second motion seeking arbitration on April 29, 2021, and the trial court ordered, after she filed that one, the trial court said, the court is in receipt of the appellant's notice of intent and application for appellants to proceed under the arbitration clauses of the promissory note. The court said the court directs that the plaintiff file a response within 10 days from entry of that date, and then the court would set a hearing to determine whether or not this matter should be sent to arbitration. The appellee responded that she didn't think that the matter should be sent to arbitration. Then on June 25, 2021, Ms. Leslie filed opposition to the appellant's opposition, saying the matter should not be sent to arbitration. In that, she said that the parties' agreement clearly showed that the parties agreed that this matter should be arbitrated. On January 4th of 2022, the trial court entered an order, and this is the important order that the trial court entered. It said that if the parties agree to have all issues in the pleading submitted to arbitration, they shall enter an agreed order submitting all issues to arbitration. If the parties do not enter an agreed order submitting all issues to arbitration, then the trial court will enter an order as to which issues will be submitted to arbitration. And paragraph 9 of that order, the judge said the arbitration clauses contained in the documents are in full effect.
So, counsel, is that really a final order denying a motion to compel arbitration? And it sounds like we're still in a holding pattern related to the fraud issue in this case. Do we really have a final order here?
I do believe we have a final order, and I cited that in my brief, Your Honor, which said, under Tennessee Uniform Arbitration Act, appeals may be taken from an order denying an application to compel arbitration under 29.503. Right now, I was going through the orders where the judge denied arbitration, but it's the fourth order where the judge denied arbitration and what he said to Ms. Leslie at that point. It's when I got involved in the case.
Can't the trial judge sort of wait on making a determination with regard to the motion to compel arbitration to determine whether fraud is applicable or not? And
Yes.
Isn't that consistent with Tennessee law to determine whether fraud, and if there's fraud that undercuts the arbitration agreement, the trial judge doesn't order it?
Well, what we think, Your Honor, is what happened in the case is it's not a question of whether or not he's holding it for fraud. He didn't send it to the trial, to arbitration for fraud. He said he wasn't sending it to arbitration unless the parties agreed to honor his prior discovery orders. And in his prior discovery order, he simply ordered that my client turn over her bank records, in which my client obviously does not want to do that.
Isn't that related, though, to making a determination of whether there is fraud in this case?
I think, Your Honor, it's related to the allegation that they put in the complaint, which is the reason they wanted the bank records is what they said is because the appellant's bank records are issues that are subject to arbitration because the appellee alleges that she discovered that the funds she had advanced were not used as had been represented to her. And so all they're saying is that she didn't pay back the money and she didn't use the funds for what she said she would be used for. The promissory note doesn't say how she's going to use the funds. The promissory note just says she would agree to pay back certain amounts of money.
So you're asserting there is no fraud here that's really at issue in this case?
We don't believe so. We think it's just thrown in to prevent this matter to be.
Have you made that argument in your brief? Is that argument advanced in your brief that this is not a fraud?
In my brief, we have not argued any of the facts because I haven't done any discovery in the matter. I got involved in the matter after the judge entered the orders telling her to elect arbitration or not. And once we let the court know that we did want to proceed with arbitration, we got on the phone. The judge called myself and opposing counsel and said, hey, what do you want to do here? Let's move this to arbitration. They said, we don't want to go to arbitration. The judge then said, I will let you guys go to arbitration if you agree to keep the discovery orders in effect. And my client opposes that. So we do, so the answer to your original question is, we do believe that that is a final order denying a motion to compel arbitration, where the trial judge has asked 4 times for us to make an election of whether or not to proceed to arbitration. As a matter of fact, the last order that cited, where he told the parties to make that election, was entered on, I believe, on March 7, 2022, the trial court ordered as follows. Defendant Kathy Leslie should inform the court as soon as practicable of her decision regarding transferring this matter to arbitration in its entirety, or whether she wants to litigate parts of this matter. That's what the court told us to do. I then sent the court an order, a proposed order saying, yes, Your Honor, we're asking to compel arbitration and transfer this matter to arbitration. And that's when he said, I'm not going to do it unless the parties agree to keep in place prior discovery rulings. And so based on that, Your Honors, and based on the case law that we cited, the question is whether or not the trial court erred by not compelling the parties to participate in arbitration, even though the parties' agreement, all 3 of them expressly say any causes or any breaches or allegations of breach are subject to arbitration. The trial court stated that the arbitration clauses are in full effect. The trial court instructed the parties to decide if they wanted to have the matters referred to arbitration. The appellant, my clients, asked that the matter be referred to arbitration, and the only reason that the trial court didn't do so is because the trial court says, I'll only do it if you agree to keep my previous discovery orders in effect. Under the cases that I've cited, we believe that the trial court has exceeded its authority by conditioning the transfer of this matter to arbitration upon the parties agreeing to keep in force the trial court's prior discovery orders. And that was a discovery order where he said one of them said for my client to turn over her bank records. The case that I've cited is Glassman, and in the Glassman case, the Tennessee Supreme Court went through and did an analysis of the Tennessee Uniform Arbitration Act, and part of that act, the court noted that under a motion to compel arbitration, all proceedings must be stayed that are unrelated to the issue of arbitrability. The issue of arbitrability has been raised by my client. Should we be in this court or not? But the court has said, I'm only going to send it, but it is related to the issue of the prior discovery orders. In the New Phase case, it has the same holding, the Tennessee Uniform Arbitration
Why
Act.
isn't the fraud aspect related to whether this is subject to arbitration or not? How are you pulling those apart?
I apologize.
Why isn't the fraud issue related to whether this is what is subject to arbitration and what's not?
Well, the fraud issue was what the court found in its very first order to say there is an allegation of fraud, but that allegation, I believe, was against my client, but it has nothing to do with the promissory notes. They're wanting to look at the bank records to see what she did with the money. The promissory notes just show that there was a clear breach. That's all it is. Did she breach it? Did she pay or did she not pay? Back to the case of New Phase case that I cited in my brief, New Phase Investments LLC versus Elite. Tennessee Uniform Arbitration Act requires the trial court to stay any action or proceeding involving an issue subject to arbitration. All the issues that the court is asked, and I think, Your Honor, how do you separate the fraud allegation from what they've put in their brief, which was they want to discover that the funds she had advanced were not used as she said they would be used for. The promissory note doesn't address how the funds would be used. The promissory note just addresses pretty clearly, I'll pay you back this money here, and that's it. It has those terms to it. It doesn't mention anything about how the money is going to be used. So we think that ordering her to give her bank records over is because they simply want to see how the funds were used, but it's not even an issue before the court in terms of resolving any of these matters here. So we think that...
Your time is up.
Thank you, Your Honor.
Thank you.
Jim Street of the Williamson County Bar for Linda Compton. I don't anticipate using all of my time, but I would like to reserve a couple of minutes in the event that it's necessary.
You don't get to.
Oh, well then I won't.
He gets to. Appellant gets to. Appellee does not.
You're right. I apologize. The question is, did the trial court err in denying arbitration? The trial court did not deny arbitration. That's not what that order says. There were 3 promissory notes that had the arbitration language in there. There were also some checks written to Ms. Leslie that we allege are demand notes. In our original petition, when she filed her first motion for arbitration, the court ruled that the complaint set out every element of fraud that needed to be alleged and that arbitration would be stayed pending discovery on the fraud question. She now doesn't want to comply with discovery. This is a discovery delay avoidance reason is why we're here. She doesn't want to comply with the discovery. Now, my client's out $300,000. There were misrepresentations made that caused her to make those loans. So we have issues that are arbitrable and issues that are not arbitrable. So my client would really like to avoid having to try this case 2 times, once in front of an arbitrator and once in front of a court. So we had discussions as to whether or not the parties would agree to submit everything to arbitration. And our response was, we'll do that as long as you comply with discovery. And Judge Martin was not going to force us to arbitrate non-arbitrable issues. He doesn't have the legal authority to do it. So this order that you're reading is when he says, if the parties agree to arbitrate all issues, sign an agreed order and I'll do it. We didn't enter into an agreed order because she's avoiding discovery. She didn't want us to have the bank records to show that she was misrepresenting things. So, one, the trial court did not deny arbitration. The trial court merely abided by its previous order that says once discovery is complete on the question of fraud, then we'll look at arbitration. Number two, the court was not going to order arbitration on all issues when only part of the issues against Ms. Leslie personally, were arbitrable under the promissory notes, but not under the checks, which were demand notes, and not under Penthouse Hospitality Group, which was the LLC that she formed and was a sole member of, and where the money went, part of the money went.
The Penthouse LLC is not a party to the arbitration agreements that were reached in this case.
And she took money and bought real estate in the name of Penthouse Hospitality Group with my client's money. She admitted that. So part of it is piercing the corporate veil of Penthouse Hospitality Group, LLC. And my client, like I say, doesn't want to litigate two cases if she doesn't have to. And if we could have the discovery, she would probably agree to arbitrate everything. It makes economic sense for a person who's out $300,000. The appellant argues that the bank records of PHG are not subject to arbitration, but he wants to take PHG to arbitration so that she can't get the records that she needs. Because arbitration, if everything goes to arbitration, then you're under it just says arbitration. It doesn't say AAA arbitration. It doesn't really specify what type of arbitration. And so once you do that, you're kind of stuck with not the right word, but the arbitrator becomes all-powerful. And he can order discovery or he can not order discovery.
Counselor, is your understanding of Tennessee law that a trial judge, when confronted with a motion to compel arbitration or a party seeking to arbitrate, can essentially hold the matter until the fraud determination is made?
I think that's what the case law says, yes. That was argument number one. Argument number two is this is not a final order. This is nowhere near a final order. And for this court to have jurisdiction, just like courts guard their jurisdiction jealously, they don't want to let parties in that don't have the standing and to be in. And here we don't have a final order. This court doesn't. I say this court doesn't have jurisdiction because it's not a final order. We don't have any language in the order that says this is a final order for appellate purposes. We didn't have an application for appeal through the trial court. We didn't have an application to this court for appeal in the event the trial court denied the application for appeal. There's nothing in there that says that's a final order. It just says if the parties don't agree, then we'll enter an order of what's arbitrable and what's not arbitrable. He didn't say I'm not sending you to arbitration. He said if you're going to agree to arbitrate everything, then enter an agreed order and do it. And if you don't enter an agreed order and do it, I'll tell you what is arbitrable. That's not a final order. So I don't know. I've looked at it and looked at it. I don't know how you read that order and say, okay, that's a final order for appellate purposes. I don't know how you get there from here. So unless you have any questions, that would conclude my argument.
Seeing no other questions, thank you. Mr. Johnson?
Your Honors, I think it is a final order. He asked us, tell us if you want to go to arbitration. We told him, he said, I'm not going to do it. So you've denied us the right to go to arbitration. Number two, as Mr. Street said, nobody wants to litigate this matter twice. So by keeping us in the trial court on some discovery matters, you're causing us to litigate all of these matters down there first, even before we can get to arbitration. How are you going to rule on the ultimate question here of whether or not those promissory notes were breached unless we go through litigation down there? And they're trying to prove that they were breached, and that not only were they breached, that she committed fraud. So he's asking us to comply with the discovery, but you're denying the arbitrator the right to do that. The arbitrator has the authority to say discovery should be done in this case, bank records should be produced, and the arbitrator has the authority, just as any other arbitrator would have who would be appointed to hear this matter, to say whether or not this promissory notes were breached or whether or not fraud was committed in this matter here. So we do believe that the order is a final order denying the right to go to arbitration, and we do believe that the judge is invading the province of the arbitrator, because the arbitrator can make those decisions as well about whether or not discovery should be conducted.
Let me ask you a question.
Yes,
If
Your Honor.
I'm following your argument here, is it your position that the trial court has no authority to decide the issue of fraud in this case?
I believe that under the case law, Glassman, that I looked at, I think there isn't a fraud exception, but when they're so intertwined, I think for judicial economy purposes, that he's giving us the right to send it to arbitration. I think that's what he's doing, but he's just exercising his discretion not to do so. But I think he exceeded his discretion or his authority when he bases his ruling on the fact that he wants us to either continue to honor his discovery rules. He didn't say, I'm making my decision on the fact that I think there's a fraud issue here. He says, I want you to continue to honor the discovery. And so I think he's exceeded his authority in that sense.
Thank you.
Any other questions, Your Honors?
Doesn't appear to be.
Okay. Thank you, Your Honors.
Thank you. Thank you both. Would you please dismiss court for today?
All right.